On September 6, 1988, Judge Barrow, writing the opinion for the appeals court in Buckley v. City of Falls Church, 7 VA App 32, wrote, "In this criminal appeal, we decide that necessity is not a defense to a charge of trespassing on the premises of a woman's medical clinic in order to give anti-abortion literature to patients considering an abortion. The defense of necessity is not available to those defendants since there were reasonable and legal alternatives to their violation of the law. The defense of necessity traditionally addresses the dilemma created when physical forces beyond the actor's control render illegal conduct the lesser of two evils." Quoting U.S. v. Bailey, 444 U.S. 394, a U.S. Supreme Court case decided in 1980. Affirming the decision of the trial court, Judge Barrow held, "In this case, reasonable, non-criminal means were available to achieve the defendant's purposes. The defendants sought to communicate with patients concerning the impact of an abortion on both the fetus and the patient. This message could have been communicated off the clinic's private property by direct intervention with the patients to the extent they were receptive to it, or by the use of placards, billboards, or other media. That these other alternatives may have been thought by the defendants to be less effective or less efficient does not justify criminal action to accomplish their purposes. Since there were reasonable legal alternatives to trespass that would have achieved the defendant's purposes, we hold that the defense of necessity is not available to them. Thus, the trial court did not err in prohibiting the defendants from presenting the defense of necessity, and we affirm the convictions." In the Commonwealth, the act of trespass was subjected for the first time to criminal penalty in 1933, and the first case brought on appeal under that statute was Com v. Hall 188 VA 72, where Judge Hudgens, writing for the appeals court, echoed the time-honored maxim that a man's home is his castle, contemplating also its cherished implications. Yet that case, decided against a group of Jehovah's Witnesses in the city of Richmond for attempting to, as the court termed, spread their corporate message in an apartment complex, was decided during a time when the civil rights struggle was in its infancy, even though the court emphasized a rash of zealous evangelism amongst that religious sect with great concern. And Judge Hudgens cautioned a common sense test as to whether the court has struck a proper balance of these rights is to ask what effect would be if the right given to these witnesses should be exercised by all sects and denominations. If each competing sect in the United States went after the householder by the same methods, I should think it intolerable if a minority can put on this kind of drive in a community. What can a majority resorting to the same tactics do to individuals and minorities? Can we give to one sect a privilege that we could not give to all, merely in the hope that most of them will not resort to it? Religious freedom in the long run does not come from this kind of license to each sect to fix its own limits, but comes of hard-headed fixing of those limits by neutral authority with an eye to the widest freedom to proselyte compatible with the freedom of those subjects to proselyting pressures, and striking a delicate balance to distinguish between a private property and a public accommodation in that case. Judge Hudgens cautioned, the inner hallways of apartment houses are not to be regarded in the same light as public roads, streets, or highways, even when the naked fee of the latter is privately owned. As was said in Hague v. Committee for Industrial, wherever the title to streets and parks may rest, they have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has from ancient times been a part of the privileges, immunities, rights, and liberties of citizens. Does the foregoing mean that the inner hallways of apartment houses, merely because they must be traversed from the street in order to reach the actual apartments wherein the tenants reside, likewise are burdened with rights which the public has in the streets? Do such inner hallways constitute places of public assembly, or for communicating thoughts one to another, or for the discussion of public questions? In the opinion of this court, the answer to those questions is clearly no. Yet even still, that case suggested that in that commercial residential complex, and knocking upon the doors of private residents, good cause was found only to call upon the assistance of law enforcement after several complaints had been made. Moreover, in 1974, in a controversy arising from a student protest at Patrick Henry High School, at which over 30 persons were placed under arrest, the Supreme Court of the Commonwealth drafted a bright-line rule as to when a principal had good cause to call upon law enforcement to demand that persons vacate the premises. Justice Harmon wrote, "Here, when the protest demonstration became unduly disruptive of the educational process and of good order and of discipline in the school, it became not only the right, but the duty of the principal to take reasonable measures to restore order so that the educational process might continue. The action taken by the principal here was not only reasonable, but demonstrated great patience and restraint on his part." Pleasance v. Calm, 214 VA 646. But in a present case on appeal in Alexandria Circuit Court, an assistant Commonwealth attorney has adamantly defended her position to deny defendants charged with trespass copies of police reports and surveillance video, inflicting harmful error to pretrial rights guaranteed by the Constitution of the United States. In defiance of Brady v. Maryland, 83 S. Court 1194, the landmark Supreme Court case that was decided in 1963, but also Bastillo v. Johnson, 63 VA Circuit 125, the 2003 Commonwealth Circuit Court case that specifically required copies of police reports and video evidence to be released to criminal defendants when they contained exculpatory material. And in this case, exculpatory, dare say exonerating material that clearly demonstrates that none of these prerequisites under the laws of the Commonwealth have been met for the police to have been called. And yet far worse, in the present case, the Assistant Commonwealth Attorney has chosen to rest the prosecution's argument in chief upon hearsay evidence that would be inadmissible in any court because it does not meet the threshold for allowance under any exception. In the present case, the Commonwealth has decided to rely upon evidence that contradicts the video record and offered by two persons who were not in any location that would have permitted them to observe without obstruction or opportunity during the mere 90 seconds it took for them to call the police. As the late Reverend Dr. Martin Luther King Jr. noted, an unjust law is no law at all. Accordingly, it is abundantly clear that in this case, reasonable, non-criminal means were not available to achieve the defendant's purpose. The defendant sought to communicate with patients concerning the impact of an abortion on both the fetus and the patient. This message could not have been communicated off the clinic's property by direct intervention with the patients to the extent that they were receptive to receive it, or by the use of placards, billboards, or other media. That these other alternatives may have been thought by the defendants to be less effective or less efficient in the face of lawlessness and abandonment of justice does justify criminal action to accomplish their purposes. Since there were no reasonable legal alternatives to trespass that would have achieved the defendant's purposes, we hold that the defense of necessity is available to them. Thus, the trial court did err in prohibiting the defendants from presenting the defense of necessity, and we reverse the convictions.
Non incautus futuri is the motto of Washington and Lee University, not unmindful of the future. My name is Major Mike Webb, and I am running for U.S. Congress. Next year, in Jerusalem, in liberty, with honor and excellence, the South shall rise again. Honest.
This advertisement was authorized by Mike Webb.